I'm Don Kerwin. I'm the director of the Center for Migration Studies of New York. We're one of the event co-sponsors, and I wanted to acknowledge and to thank the other co-sponsors, the Cabrini Center for Immigrant Legal Assistance of Catholic Charities of Houston, and Wafa Abdeen, who's here in the front row, the Houston Immigration Legal Services Collaborative, Kate Vickery, who's somewhere here, all the way in the back row, and also our host, the South Texas College of Law. Thank you very much. We also had a long list of people that were advisors to the planning committee, and we thank them, and they're listed in the materials. I think it's something like 18 people. So the idea of having this event in Houston came from a study that CMS conducted with Roberto Suro and Tess Thorman, who are here today, and which was supported by Rebecca Carson and the Open Society Foundations. And the study was on the implementation of the Deferred Action for Childhood Arrivals, the DACA program, and how that was implemented by CBOs and NGOs across the country. We studied 5 communities in particular very intensively, one of which was Houston. And at the time, of course, we hoped that the DACA program would be a test run for a large-scale legalization program. And of course, that didn't happen. We came away from the work very, very impressed, I would say, with the community response to DACA. And we concluded that that wasn't due to a frantic few years of work, although that was part of it, but it was also due to 25 or 30 years of institutional capacity building, building advocacy voice, and building expertise in the pro-immigrant community in many areas. We found that capacity building took many forms: more community organizing, more work between community organizers and lawyers, expanded DOJ recognized agencies and accredited representatives, greater legal expertise on immigration by lawyers and accredited representatives and volunteers and by immigrant communities themselves. The ability to pivot from one large challenge like DACA to another, like the kinds of challenges that we're facing now, greater leadership and participation by immigrants in the affected communities in these kinds of efforts, effective use of technology, and greater availability and use of demographic data. All these were areas of capacity building that we were very impressed by. And we were impressed with really all of the communities we visited in different ways. However, we were particularly impressed with the way that Houston groups had banded together to create this kind of whole of community response to the DACA program. I think many of you witnessed their coalition, some of the groups yesterday, those who were on the site visits, but it's really impressive. So our report comes out, and then the election takes place, and you might argue that the election changed everything, and it did and it didn't, but what it did is it certainly made it more important, the need for all of the work that you all do. Federal litigation has always been extremely important in the pro-immigrant community, but it's been really overwhelmingly important over the last 125 days, as we know, and we're going to talk about that. We have a superb panel to talk about those efforts today and how communities can engage and prepare for litigation and inform litigation. There also there was a need for legal screening of the undocumented prior to the election, and as we know, that need has grown quite substantially since the election. There's an immense need for this kind of whole of community model response to the new federal agenda, as well as to challenges like SB 4 and to opportunities for immigrants at a local and state level too. In many states, I think prominent among them Texas, there's a particular need for municipalities to step up, to protect and defend all of the members of their communities. The city of Dallas needs to be applauded, I think, today for the important step it actually took yesterday by joining Austin and San Antonio in the lawsuit challenging SB 4. That was a great moment. So since the election, many of your agencies and networks have pivoted from DACA and other priorities to responding to this very changed landscape. And so we decided to organize an event in an effort to understand, to strengthen, and to extend this work. Immigrants and refugees are under siege in the United States to an extent they haven't been in most of our lifetimes, I think. And what feels different about this era is not just the restrictive immigration and refugee policies, but the challenge to the very identity of our communities and the nature of our nation and its values. Are our communities committed to protecting and serving all of their residents, or aren't they? Is immigration enforcement like our only value, or do we also care about families, due process, protection of those fleeing for their lives, and the welfare and safety of our communities? Are we a nation defined by race, ethnicity, religion, ancestry, and other characteristics that people can't change or in good conscience shouldn't have to change? Or are we a nation defined by shared ideals like justice, equality, opportunity, human dignity, and the common good? And I might add, are we committed to the institutions that preserve these ideals? Institutions like an independent judiciary, a free press, robust civil society, and our system of federalism, our constitutionally mandated system of federalism. If we share the latter vision, which I think most of you do, I hope all of you do actually, the question is, how can we advance that vision in these circumstances individually, as part of our agencies that we're involved with, and collectively as communities? That's what this event is really about. And we're starting now knowing that people will be coming in, leaving, over the next 2 days, but we really have an excellent agenda. It's very, very ambitious and full, as you can see. And I'm not going to go over it all, but let me just speak briefly about today's agenda and about our breakout sessions today. So our first plenary panel is going to cover enforcement issues with the idea of creating an evidence base for the next 2 days. This is what you need to know about enforcement to have the kinds of conversations that we're going to have over the next couple of days. The next panel is going to feature the Houston Immigration and Legal Services Collaborative, that model here in Houston, and what Houston is doing now to mobilize in defense and support of immigrant communities, which is very impressive. And the third panel will then cover the whole of community responses to changing policies and to the changing landscape in other communities, like Los Angeles and the greater Washington, D.C. area, and Miami and Tucson, and through different networks as well, like the PICO organizing networks. And these opening sessions will set the stage for our first set of breakout sessions, which will take place after lunch, starting at 1:35 p.m. sharp. So please, as Rachel said, each of you are assigned to one of the breakout sessions. They're kind of color-coded, and we'll be telling you what rooms you'll be going to. But please show up at those breakout sessions on time at 1:35. We have excellent moderators for those: Tess Thorman, Vin Ho, Father Cleet Kiley, Carlos Duarte, and maybe a fifth person, I'm not sure. Each of today's breakouts are going to cover the same theme, which is how communities are organizing, how they can strengthen their collective work, and what we can learn from each other. And they're intended to be an opportunity for you to speak on what's working and the top priorities and needs of your communities. And we'll be asking the groups to return to this room after 30 minutes or so to provide short reports on their conversations. We're hoping to take all of this information and produce some kind of a report or a record on it. And I think it could be a very powerful record and kind of an inspiring record. By contrast, tomorrow's breakout sessions will cover a range of topics which you'll find in the agenda. But I want to say this: if you want to, over the course of the next couple of days, if it occurs to you that it would be great to have a conversation with a group of organizers on a particular topic or particular need, you're welcome to propose that to somebody at the front desk. And we have formal space for it, at least one, and then we can also create other space for smaller types of conversations. So, that's pretty much it. As a rule, I would say that we're very interested in looking beyond the normal pro-immigrant groups to the institutions and that really need to be involved in this work to make these whole of community responses effective. particularly those that aren't at all or that aren't to the degree that they have to be. Which institutions and individuals need to step up? And what can we do to engage and mobilize them? Because it's really the moment to step up and be counted. It's going to be too late a year from now or 2 years from now or even 6 months from now. And I was reminded recently of what Martin Luther King Jr. said. He said, in the end, it's not the words of our enemies, but the silence of our friends that we'll remember. And I think that's absolutely true at this moment. Are your communities and are its key institutions fully engaged in this crucial work at a time when it really matters? If not, how can we work together to make that happen? So thanks to all of you for being here, and thanks in advance for your contributions over the next 2 days. And let me stop there and ask Wafa in the first panel to come forward.
Good morning. I'm glad, even though you had really good time yesterday, you were able to come and, hopefully you will come with your questions and contributions and be part of the discussion today. So this panel is really going to start with the basics first. So we have, been talking about the new Trump era and what happened. And all of that started with the executive orders and the memos that were issued right after that. So like within the first week, we had 2 memos that affected and impacted immigrants and refugees in very, important and really disturbing ways. And Catholic Charities, as a nonprofit organization that is working with immigrants, have seen the fear in the community, have seen how, how afraid they are to go to report to ICE, to be at home and have ICE come to them or other enforcement. So I wanted to kind of really start a little bit with the executive orders, and I'm sure a lot of you have, looked at them, but I thought this will kind of start the conversation. We had 3 executive orders. The first one was enhancing public safety in the interior of the U.S. The second one dealt with border security and immigration enforcement improvement. And the last one was protecting the nation from foreign terrorist entry into the United States. We had one issued first, and then as a result of the litigation, the president rescinded the first one and issued a new one. And actually, I mean, one of the sessions that we will have later will be about the lawsuit, so I'm not really going to talk about it at all. So what did the first one do? It really concentrated on 2 things: removal of immigrants and expanding immigration enforcement. And what it really did, those of us who have been practicing immigration law for a while have been relying on the 2014 memo that set the priorities for the administration in terms of who would be picked up, who would be detained, and who would be deported. And it's really concentrated mainly on people who had criminal records and serious criminal records. So this is now out of the door. The priority have completely changed. So who became the priority? So anybody, we said, with criminal convictions. But now this has been expanded so much to include people who are even charged with a crime, people who are suspected to have a crime, or someone who immigration officials think may pose a danger or be guilty of a crime. Those who committed fraud and misrepresentation, and those who abused public benefit. And anybody who was ordered deported and did not, was not deported even if they don't have any criminal record. So also some of the things that we heard from Don are very clear in these orders. So first of all, beefing up the number of staff who are going to be part of the enforcement. So hiring 10,000 more Border Patrol. And then reviving all the community enforcement, which was partnerships between local police and the immigration, and also defunding states and cities that are considered to be sanctuary city, which, as we know, this is not really a real term, but anybody who's not ready to cooperate with law enforcement, and removing privacy for immigrants, as well as pressuring foreign communities to take people that will be deported outside and wait for their cases. Then the border security and immigration enforcement, it was mainly to deter immigrants. So build a wall, as we know, at the border, and build more detention centers, because everybody now is a priority, and indefinite detention for immigrants. Even asylum seekers will be in detention until their cases have been completely resolved. Hiring also 5,000 more border patrol and deputizing state and local enforcement to enhance immigration. So, and then there were two memos that were issued right away that kind of explain more, or, you know, the implementation of these orders. So as we said, rescinding the priorities, so everybody became a priority. Reinstating secured communities, and 287G, eliminating most of prosecutorial discretion except DACA. For now, it's still there. And fast-track removal. So now, I mean, a lot of the due process that was available for immigrants is not going to be there anymore. So they are able to really detain anybody. We do a lot of work with unaccompanied minors. So one of the disturbing things is that there will be a redetermination of the designation of unaccompanied minors once they are reunified with their parents. And then prosecute anybody who facilitates the entry. So the parents who paid for their kids to come here or ask an aunt to bring them might be charged with abetting and aiding, you know, illegal entry. Now also, as we said, everybody is subject to being deported. And there were themes that we heard throughout the election, like, you know, the catch and release. So now they're supposed to be really not releasing anybody, even though they have an, you know, an asylum case. This would have a chilling effect on it. And also, if you remember, expedited removal was available for people who are within 100 miles of the border and have been here for 2 weeks. Now it's expanded to the whole of the US, and as long as they have been here less than 2 years, they can be expeditedly removed without any due process. And then, you know, expanding the communities for CBP. So these are really what we're going to be talking about. And even though, you know, some people believe they started, but really they are grounded in policies and in statutes that have already been there. So we have two great speakers who are going to really talk about these themes historically, and also talk about their research about that. I just wanted to go quickly just about the third one. This had to do with the entry of people from 6 Muslim countries, as well as banning refugees for 180 days. And you know, part of it too was reducing the number of refugees who are allowed to come in. So I'm really, you know, that's kind of really what we're going to be talking about. And I want to introduce my two speakers. So we have Michael Kuhn. He's an assistant professor of economics in the Sykes College of Business at the University of Tampa, where he teaches principles of microeconomics and international trade and finance. Previously, he was an assistant professor at Hood College in Frederick, Maryland. He was awarded the Dr. Henry P. and Paige Laughlin Faculty Professional Achievement Award. His primary research interests are empirical microeconomics, particularly in the area of economic development, and the economics of migration and income remittances, and household labor decisions. Today he's going to talk a lot about the enforcement programs that are partnerships between local enforcement and the federal government. We also are excited to have Emily Rio, who is an associate professor of law and sociology at the University of Southern California, Gould School of Law. She received a JD from Harvard and a PhD in sociology from Stanford University. She served as law clerk to the Honorable Margaret McCone of the Ninth Circuit Court of Appeals and practiced law at the International Law Firm of Cleary, Guggenstein, and Hamilton. Her current research focuses on immigration law, criminal law, legal noncompliance, and legal attitude of non-citizens. She has published widely in both leading sociology and law journals, including the American Sociological Review, Social Forces, Law, and Social Inquiry. She has been awarded the 2017 Andrew Carnegie Fellowship that will support her empirical work on immigration detention. So I just wanted to start by also saying two things about what's happening in now as a result of all of this. So we have more immigrants being detained. People who are victims of crime are not able to really to call the police because they're afraid they're going to be deported. So this will lead us to the first presentation. Michael will talk about these enforcement programs and highlight them historically and where we are today.
Thank you very much. Today I'm going to talk to you about the programs covered in the executive order signed on January 25th, which is the Enhancing Public Safety in the Interior of the U.S. As Wafa said, these programs are not new. They've been around for quite some time. What's happened with the executive order is the change in the way that they've been enforced. So I thought I'd start with a brief overview of the history of these programs, how they've been enforced, how they've changed over time, talk a little bit about the academic research around their effectiveness and the other effects of these programs, and then talk about the state of where it's going in the future. The most widespread of the programs in terms of coverage in the United States is the Secure Communities Program. The way that the Secure Communities Program works, as a matter of routine, when somebody is arrested, the arresting officers, as they're being booked into the jail, typically run their fingerprints through the FBI in order to do a criminal background check and see if they have any prior convictions or if they have any outstanding warrants or anything like that. What Secure Communities did was linked up the databases between the FBI and Homeland Security, and so now while they're checking for criminal backgrounds, they're also checking for immigrant violations. So if somebody has overstayed their visa, or if they have a deportation order, or they've been deported in the past, then the individual will be flagged. Homeland Security will be notified. They'll notify the local arresting agency, and if they intend to deport them, then they'll issue what's known as a detainer, where the local agency can then hold the individual for 48 additional hours to give time to transfer them into federal custody and issue and start deportation proceedings. This program began in 2008. It started with just a handful of jurisdictions. Because it's costly to implement, they started off little by little with the goal of expanding it to cover all 3,000 plus jurisdictions in the United States by 2013. The program was discontinued in 2014, and then it was revived again through the executive order. One of the key features of Secure Communities, though, is that in order for somebody to be flagged, they have to be in the database, right? So this is only going to cover individuals who entered the country legally, right, and gave their fingerprint upon the port of entry, or somebody who had prior contact with the police and had been fingerprinted by the police or by Homeland Security. So anybody who is in the country illegally that has never had any contact with law enforcement, right, wouldn't be flagged under this system because their fingerprints aren't in the ident database, right? But the 287G program, which is a slightly different program, kind of closes this loophole, if you want to call it a loophole. What the 287G program does is it allows local law enforcement agencies to enter into partnership with Homeland Security under what's known as a memorandum of understanding, where the local agents are trained to enforce immigration law, and they identify individuals' immigration status through personal one-on-one interrogations. Right, and so this is a much more costly, time-consuming process, right, where Secure Communities, they just run your print through the program and it automatically checks and cross-references. Under the 287G program, they have to do kind of personal one-on-one talks, right? But what this does is it creates what's known as a force multiplier. So there's only a limited number of ICE agents who can usually do this proceeding, and now so they're co-opting the local law enforcement agencies to do the work of ICE as well. The 287G program was started in 1996 under the Illegal Immigration Reform and Immigrant Responsibility Act. Although it was started in 1996, the first memorandum of understanding wasn't entered until 2001 after the 9/11 attacks. Nobody really wanted to be part of this program. After 9/11, Florida was I forget which jurisdiction in Florida, it might have been the Highway Patrol, don't remember. But given that the 9/11 terrorists had got their flight training in Florida, they really felt that they dropped the ball and they had to do something, and so now they were going to use this program to help counter terrorism, essentially, is what they wanted to do. The 287G program can operate in a couple of different models. The most common is what's known as the jail enforcement models, in which case it operates somewhat similarly to secure communities, where anybody who's arrested and booked into the jail is asked about their immigration status as part of the intake process, right? So they're interviewed, and this is everybody who comes into the jail. Essentially, the interview is they ask, where were you born? If they say they were born in another country, then are you here legally? Can you prove it? Et cetera, et cetera, et cetera. The other way that this program can be implemented is what's known as a task force model. In that case, officers are actually trained to enforce immigration law out in the field. So the key difference between these two models is under the jail model, an individual has to be arrested for something else and brought into the jail, and only then can they find out their immigration status. Whereas in the task force model, the officers can actually arrest somebody for an immigration violation. Or officers can detain while they bring one of the deputized agents to come in and do the arrest, and they can also enforce immigration warrants as well. And then there's a combination of these two models known as the hybrid model, where you have everybody in the jail being booked, and then also you have task force officers in the field. As I mentioned before, the 287G program was signed into law in 1996. The first memorandum of understanding was issued in 2001. The number of agreements has fluctuated over time. I believe the high point was somewhere around 90, 95, if my memory serves me correctly. After Secure Communities was fully implemented in 2013, Homeland Security announced that they were going to stop renewing memoranda of understanding and as well as issuing new ones. But after Secure Communities got scrapped, they started issuing 287G memorandums of understanding after that. Currently, there are 42 jurisdictions with memoranda of understanding. About 10 of these have been signed in the last 6 months, so after the executive order. And actually, so I looked up the number yesterday to get the most current number from Homeland Security. The last time I looked at it was about a month ago, and in that time there were 6 new memoranda of understanding signed, so just within the last month. And I know that there are several other jurisdictions that are considering them. One of the largest being Baltimore is looking at issuing one. Just on kind of a local level, 5 jurisdictions in Texas have 287G programs. They're the Carrollton Police Department and the Lubbock, Jackson, Smith, and Waller County Sheriff's Offices all have 287G programs in effect.
And Mike, I wanted to mention the biggest, department was the Sheriff Department of Harris County. We were able to really advocate, and it was, the whole community that worked on it, and we were able to convince the new sheriff to stop the 287G, and he did, but then all of these other new, smaller or suburban, really, departments started having, and it's every day it's increasing, actually. Thank you for pointing this out.
Yeah, and that's one of the, I was going to kind of maybe save that for the Q&A session, but one of the biggest kind of issues is that a lot of times the sheriff's office can enter into this arrangement without any approval from anybody else, right? So it never has to be taken to the voters, it never has to go through the county council, depending on the jurisdiction. Some places it has to go through city council and all that to get approved because they have oversight over the sheriff's department, but a lot of times the sheriff can just unilaterally enter into these agreements with no recourse for the population. The jurisdiction where I'm going to be talking about the research that I've done in Frederick County, basically that's what happened. The sheriff entered into this program. He's got huge backlash from the community about it, and just basically says, I don't care what you say, I'm keeping the program, I like it, deal with it. And that's basically their response. So those are the two enforcement programs that I want to talk about today. I'll talk about a little bit about the priority enforcement program towards the end. But what we want to really think about today is what are the concerns with these programs, right? What are the issues that arise when having a program like this in place? And there's two main questions that come to my mind from a policy perspective. The first one is are the programs effective, right? And the second one is, are the programs discriminatory, right? So those are my two areas of concern. The question of effectiveness really depends on how you define effective, or what are the goals of the programs. If the goal is to deport immigrants, both of these programs have been very, very effective. Tens, if not hundreds of thousands of immigrants have been deported under these programs. But those, deportation in and of itself is not one of the stated goals of these programs, right? If you recall the name of the executive order that was signed on January 25th, it's the Enhancing Public Safety in the Interior of the U.S., right? And so the question is, do these programs make the communities more safe, right? And the idea that these programs would make communities more safe is deeply rooted in a fallacy that I'm sure all of you are well aware of, right? There's a common belief that immigrants are more likely to be criminals than natives, and therefore removing immigrants is going to make the community safer, which the actual fact is the complete opposite of that, right? Immigrants commit crimes at a much, much lower rate than natives. And so, if anything, removing immigrants from the community is going to make the community less safe. And the research has shown that communities that have higher immigrant populations tend to have lower rates of crime overall. And so the question of public safety really comes down to an empirical question of whether or not they improve criminal outcomes. So with secure communities, there have been two large comprehensive studies looking at the effect of secure communities on crime. There's a 2014 study published in the Journal of Law and Economics that found, and I quote, secure communities did not cause a meaningful reduction in either the FBI's overall crime rate or in the rate of violent crimes. All right, so what the researchers did was they looked at the way that secure communities was rolled out through the country and looked at the rates of crime. Both there's an aggregate FBI crime index, and then the FBI Uniform Crime Reports breaks down crimes according to categories of violent crime and property crime, and they look specifically at murder and rape and larceny and robbery and burglary and car theft and all of these things. And so the researchers found that there was no impact whatsoever on most crimes. The only reducing effect was they found that there was a slight reduction in burglary and vehicle theft, but it was very small. It reduced the rate by approximately 1 to 2%. Right? So if you think about the number of people who were arrested and deported to decrease burglaries by 1-2%, it's not a very cost-effective program. And then in terms of enhancing public safety, the really terrible crimes that we're concerned about, violent crimes and the like, it had no impact at all. There was a similar study published in the Criminology and Public Policy Journal, which used slightly different data set and slightly different models, but found essentially the same conclusion, that secure communities had no impact whatsoever on reducing crime. In terms of whether or not the program was discriminatory, the same authors who published the study in the Journal of Law and Economics had a follow-up study in, I believe, the Chicago Journal of Law that looked at the motivations for the way that it was rolled out, right? So they rolled out the program in stages, adding at first, I believe the first was like 14 jurisdictions, and they added 50, 100 at a time until they got complete coverage, right? So if the motivation was to reduce crime and improve public safety and make communities more secure, right? Their hypothesis was that, well, given limited resources, you would want to target the most unsafe communities first, right? So if they were really going after reducing crime, they should have implemented the program in the highest crime jurisdictions first, and then slowly work their way to expand to lower and lower crime. They found that the rollout had no correlation whatsoever on the crime rate in the jurisdiction where it was being implemented. In fact, the number one indicator of whether or not a community would get the program next was the share of the Hispanic population. Right? And so it was blatantly discriminatory. It was clear from that, because Hispanic population is somewhat of an indicator of immigrant population, that the real aim of the program was not, in fact, to secure communities, but in order to deport immigrants, right? And so it became widely known and understood that this was very discriminatory. In terms of the 287G program, there haven't been, as far as I know, any similar studies like there have been with secure communities on a comprehensive level. The main reason being is that the 287G program is very obscure. Usually when I talk about my research on 287G, I have to give a really long talk about what it is, because nobody's ever heard of it. So if nobody's ever heard of it, nobody's really looking at it. The other is that 287G programs are really hyper-local, so getting data at the level that you would need to conduct a study is very difficult and time-consuming. There have been some studies on certain jurisdictions. A lot of them have been qualitative, so when a 287G program is implemented, they ask individuals their feelings about the 287G program and how they might change their behavior. In general, these studies have found that there's a sense of fear in the community, particularly among the Hispanic population. And I say Hispanic and not necessarily immigrant population, because again, these programs tend to go in places with high Hispanic populations, and there is a discriminatory bias because when people are looking for immigrants, right, they can racially profile, and so there's a fear among the Hispanic community that they're going to be racially profiled and targeted. And so some of these qualitative interviews have found that the Hispanic community will do things like stop leaving the house unless it's absolutely necessary, or they will stop driving and start taking public transportation or walking so they don't get arrested for a traffic violation. A lot of this is really anecdotal. I mean, it's just kind of one-on-one interviews with a handful of people. I conducted a study of my own on Frederick County, Maryland, kind of a more quantitative, data-driven study looking at the effects on the 287G program there. To give you a little background, Frederick, Maryland is in western Maryland. It's about 30 miles outside of Washington, D.C. It does not have a very large immigrant population. It has, I believe, the 2010 census, the foreign-born non-citizen population was about 4% of the population, compared to neighboring Montgomery County. It has a foreign-born population of about 20%, right? And they don't have a 287G program. And so the Frederick County Sheriff's Office entered into a 287G program in 2008. What's kind of an interesting thing about that is that there's two main police jurisdictions in Frederick County. There's the Frederick City Police, which has jurisdiction over the city, obviously, and then there's the Frederick County Police, which has kind of the broader jurisdiction over the entire county. But the Frederick County Sheriff's Office also runs the jail system. All right, so anybody who's arrested by the Frederick City Police goes into the Frederick County Jail. And so Frederick County Sheriff's Office started a hybrid model program where they had both the jail enforcement model and the task force model, which would allow the Frederick County Sheriff's deputies to arrest people for immigrant violations. But then anybody who was arrested by the Frederick City Police also came into contact through the jail system. And so what I wanted to look at were two things. One, was there what we call the chill effect, right? So as I mentioned before, if there's a feeling of fear and people will start avoiding the police, typically what you'll see in these cases is you'll see a decrease in the number of arrests. Not because necessarily that the community is getting safer, it's just that people are afraid to call the police, right? And so you're starting to see some of this now in news reports about domestic violence victims who don't want to call the police because they're afraid of being deported, witnesses who don't want to cooperate because they don't want to have to talk to the police because they're afraid they might get deported. And then I also wanted to look at whether there was any racial bias in the arrest patterns among the sheriff's office. So the hybrid model gave me a nice kind of statistical trick to do both of those things at the same time. And basically what I found was there was evidence of both of these, right? So there was a significant decline in arrests by the Frederick Police Department among the Hispanic community at a time when arrests of blacks and whites were going up, right? So it was doing kind of the Hispanic community was following the opposite crime trend of the other races in the city, which typically they tend to find, and they tend to go in the same direction. But the opposite happened for the Frederick County Sheriff's Office. So there was actually an increase in the arrest of the Hispanic population by the Frederick County Sheriff's Office because of the program. But there was also a decline in arrests of the white and black population as well. So What this tells me is that there was definitely evidence of the chill effect, especially among the Frederick City police, partially because you don't want to for fear of being deported, people started avoiding the police. But then also on the part of the Frederick County Sheriff's Office, there was a significant shift of resources away from the black and white community towards the Hispanic population, right? The question that we want to think about then, right, is if the effects of these two programs are either, again, if you have the chill effect, that's typically going to lead to a decrease in public safety, because if people are afraid to report crimes, then criminals become more brazen and they're more likely to commit more crimes, right? So it's actually making communities less safe. So the priority enforcement program was put in place to kind of counteract a lot of these effects and only target the most serious criminals, to rebuild relationships between the police and the community, to have low-level offenders be not afraid, have witnesses and victims not be afraid. And so the executive order reverses both of these. Right? So it reverses the priority enforcement program, brings back secure communities, expands the 287G program. So if you want to think about what we can expect going forward, is we can expect communities to become less safe. We can expect crime to increase. We can expect victims and witnesses to be afraid to come forward. We can expect more racial bias in policing. And we can expect just an overall level of chaos and fear and terror going on throughout our communities, especially among immigrants and Hispanics. And so I will stop there and wait for questions after Emily speaks.
Thank you so much. And I wanted to also highlight that here in Harris County, the HPD has said that there was a drop of 42.8 from Latinos reporting crimes in the first 2 months of the year. So I mean, really what you have heard from in terms of research and what is happening and how this whole, enforcement, regime and the reviving all of this has this chilling effect. And mostly we see it a lot in our work also with crime victims. So there is also a 25% drop of crime victims who are trying to really kind of get help from the police. And a very important also, issue in terms of policy, local enforcement is supposed to be protecting the community. So it is eroding the trust and the relationship between the communities they're supposed to be protecting and these communities, which will, in addition to having the chilling effect and more crimes, will also, affect relationships between them. Now, Emily is going to talk about detention, and she'll talk about it historically. But then, a lot of her research really has been around how do immigrants see themselves. They are really kind of defined by statutes and by the media, but they see themselves differently, and we hope to hear a lot about that. Thank you.
Thank you. Thank you for organizing this panel. I'm really thrilled and honored to be here today, and looking forward to the conversation that we're going to be having today and tomorrow. Just as a way of quick introduction to the kind of work that I do, so I'm an empirical legal scholar, and which means I study the law, legal institutions, legal actors, including immigration lawyers, immigration judges, and most importantly, immigrants themselves, and the ways in which they might interact and try to navigate our legal system and interact with our legal authorities. And I study these issues both quantitatively and qualitatively using social scientific methods, which means I do analysis of large sample size data sets, but I also do in-depth interviews with smaller sample subpopulations. So in terms of the contribution that I want to make to this panel today, I wanted to basically highlight 3 key ideas that has guided my own work that I hope might be helpful for some of the conversations that we're going to be having today and tomorrow. And I want to use my research that I've been doing on immigration detention to try to illustrate what I mean by some of these arguments that I'm going to be making. So let me just first start by previewing very briefly what these three key ideas are, each of which actually try to answer the questions, the how question, the what question, and the who question. And the running theme, as you'll see in a minute, across these questions is the argument that we really should be taking a broader view on how we answer these questions with respect to immigration enforcement and immigration detention in particular. So the first point that I want to highlight is that in thinking about how we should go about measuring the impact of our immigration policies, I think it's important to consider the views of migrants themselves, whose lives are obviously being directly impacted by these policies. And this is what I call the subject-centered approach to studying immigration law. And by that I mean, of course, it's extremely important to try to understand, to try to measure, and to try to consider the aggregate social and economic and legal consequences of these policies using, for example, macro-level data. But that it's also critical for us to understand these policy impacts from the standpoint of the migrants themselves as they understand the laws and policies and as they experience these laws and policies. The second point that I want to make is that in thinking about what is the impact of our immigration policies, I think the natural instinct for all of us, including myself, is to focus on the immediate, the direct, and the tangible impacts that are easily measurable. But what I want to argue is that we ought to also pay just as much attention to the long-term indirect effects. And so an example of this in my area of research that I've been doing is to try to understand how our enforcement practices and the ways in which our enforcement practices might be teaching hundreds and thousands of non-citizens every day about the nature of our legal system and even the very nature of our democracy and the rule of law itself. The third point that I want to make is that in thinking about, the impact of our immigration policies, we should really keep in mind that although immigration law is viewed through the lens of and is governed by domestic laws and policies, that in terms of its consequences, that these laws and policies really have consequences that are international in scope. So what I want to do now is to illustrate these 3 points by sharing with you some of the examples from the research that I've been doing on immigration detention. But before I do that, let me actually just give you a brief sort of historical view and some basic statistics to set the context for what I'm about to talk about. So here's a general trend that I'm showing you in terms of the growth in the number of people that ICE has detained in the past 15 years or so. So between 2001 and 2013, 2014, the detained population more than doubled from a little over 200,000 to more than 425,000 in 2014. As many of you know, immigration detention is also extremely costly. So in 2013, for example, the Department of Homeland Security spent about $5.46 million a day on average on immigration detention. I'm sure many of you, most of you, all of you already know this, but I just want to remind us that the reason why non-citizens are in immigration detention is that they're accused of allegedly violating immigration laws, and they have been placed in a removal proceeding. And if they contest the removability, then they have to appear before an immigration judge after a long period of wait, given the huge backlogs that our immigration courts are experiencing. And in the meantime, now they're being held in civil confinement. Under the law, immigration law is civil, immigration detention is also considered to be civil, which means it's not treated as criminal incarceration. And that also means that immigrant detainees do not have the same kind of due process rights, are not provided the same kind of rights as criminal defendants in the criminal justice system. Here's a breakdown in terms of the top 10 countries of origin for individuals who entered ICE detention in 2013. You can see that Mexico is that, and then followed by Northern Triangle countries of Guatemala, Honduras, and El Salvador, really predominate the bulk of this population. Now, in terms of Trump's executive orders and the policy memos that followed from the Department of Homeland Security, let me just very quickly summarize what those main points are with respect to immigration detention. So first, the administration believes that immigration detention ought to be the default for everyone that's apprehended, because apparently Trump believes that it's the most efficient way to enforce our immigration laws. So the plan is to, one, find more bed spaces, detention beds, in the existing jail complexes, local jails and prisons, as well as to build new facilities. And so there's going to be a dramatic expansion in the number of facilities. The second main key change here is to hire more asylum officers and immigration judges. And the goal is to send them to detention facilities to actually do the credible fear hearings in detention facilities and to adjudicate cases in detention facilities. And then finally, the plan is to make the detention facility contracts more appealing to the contractors. The administration is planning to close down ICE's Office of Detention Policy and Planning, which is basically an agency that was created under the Obama administration to basically ensure and to improve the health and safety of the detainees, and the plan is to eliminate that agency altogether. Here's a couple charts just to give you a sense of how we compare, how the U.S. compares to other traditional immigrant receiving countries. The one at the top shows you just in terms of the total number of detainees in the U.S. in 2010 compared to UK, Canada, Australia, which are the other traditional immigrant receiving countries in high volumes. The one below that shows you per capita, so per 10,000 immigrants in the country, what the detention population looks like, and you can see we're excelling at this at the head of the pack, which is not a good thing. In terms of what detention looks like on the ground, if any of you haven't been to detention facilities, they very much look like criminal incarceration. They very much look like local jails and prisons. There's practically very little difference. And this is obviously because our federal government contracts with hundreds of local jails and prisons, as well as with for-profit prison companies that build these facilities that are modeled after the penal model of confinement. Now, I want to talk a little bit about, explain to you who the people are in my data set. So let me just spend a minute giving you a rundown of who the people are in the data set and what my research design looks like. So for the past few years, I've been doing survey and interview work with immigrant detainees to try to collect data, to try to better understand the experiences of detention, as well as what happens to them if they get released from detention while they wait for their removal proceedings, and to try to think about what the economic, social, and legal impacts are of detention. So this data that I have pertains to non-citizens who are in removal proceedings who are part of this class action litigation that many of you might be familiar with called Rodriguez versus Robbins. And this is a case on which I served as an expert data consultant. So very briefly, for those of you who are not familiar with Rodriguez case, it involves long-term detainees, and by long-term, I mean detention that lasts for a continuous period of 6 months or longer. So for many people in this data set, the detention period is actually much longer than 6 months. And these are detainees in the Central District of California who have been held for at least 6 months. And now they're seeking an injunction against the government practice of holding them without any kind of an individualized hearing as to whether or not they pose a flight risk or danger to the community. And so in effect, they're being indefinitely held until their cases can be heard before an immigration judge. So the district court actually granted this injunction several years ago, which meant now the class members have been receiving bond hearings. And the case was then, and a decision was then affirmed by the Ninth Circuit, went up to the Supreme Court late last year in November or December, and now we're waiting for the Supreme Court to make its decision. So here's an overview of what my data looks like. So on your left, I've highlighted these sets of data as subject-centered, which is the first argument that I made. We ought to be really paying close attention to how these laws are impacting the migrants themselves from their perspective. So we have a baseline survey. These are surveys of individuals in detention. If the detainee gets released, whether it's on bond or supervision conditions, then we reached out to them over the course of months and kept in touch with them. And then we did an in-depth interview with them during the first year of their release. So both the survey and the in-depth interviews are examples, basically, of trying to understand the experiences and the release process from detention, from their perspective. But we also collected non-subject-centered data as well. So, for example, we visited the immigration courts in Los Angeles. So I would go with my law students and sit in through these hearings, collect data that could be then coded. We also have audio recordings of these bond hearings that over the course of the last year I was able to code up and to try to analyze in terms of what is happening in these bond hearings themselves in these courtrooms. So here are some pictures of the detention facilities where the detainees are being held in my study. 3 of them are county jails that contract with ICE. One of them, the last one at the bottom, an Adelanto facility, is one that is being held, that was built by a for-profit prison company, really one of the big ones called GEO. Here's a picture of an immigration court if you haven't been to immigration court, and at the bottom are detainees who are being led to their bond hearings. As I mentioned, now there's an increasing push to actually build immigration courts inside detention facilities so that the detainees can have their hearings in the detention facilities themselves. There's also an increasing trend toward video hearings so that the detainees are in their detention facilities confined while the hearing is happening through video in the immigration courts that are pretty far away from the detention facilities. Here's some basic background characteristics of the detainees in my sample. Majority of them, over 90%, are men. About 90% are Hispanic or Latino, or self-identify so. They've been in the United States on average about 20 years. Many of them, about 70%, have U.S. citizen children or lawful permanent resident children or spouses in the United States, and about 90% of them had been employed either part-time or full-time in the United States. So what we have is actually a population that is pretty deeply rooted both economically and socially in the United States. Now, if you'll remember, the second argument that I made at the top of my talk was that we ought to really consider the long-term indirect effects as well as short-term direct effects of our enforcement policies. And so to illustrate this point, I want to share with you some of my findings on the attitudinal impacts of detention. And in particular, I want to focus on something that I found was quite prevalent and common among the detainees that we spoke with. This is what I call legal cynicism among the detainees. And very, very simply, by legal cynicism, what I mean is this sense of, just this fundamental sense of distrust that detainees come to acquire about our legal system and our legal authority. So here are a few statements to sort of concretely illustrate what I mean by this. So we have Jose who says the law isn't the same for everyone. Edson told me it's just the luck you have, honestly, the judge you get and how they're feeling that day. And then Danielle who says it's like the court system doesn't want you to be free to do anything. That way you can just give up. It seems like that. Okay, to sort of keep myself organized, here's a diagram that summarizes my findings on legal cynicism, and so I just want to very quickly go through the different subtypes of cynicism that I encountered on the field. The first is this idea that even though immigration detention is civil, not criminal, that legal system as they experience it and detention as they experience it is extremely punitive. And then there's this idea that legal rules are completely inscrutable to them from their perspective, meaning completely incomprehensible, and by design, not by accident. And then the last idea is this notion that legal outcomes, from their perspective, are arbitrary and random. And so what I try to do is to explore what are some of the underlying factors, structural factors, interactional factors, that might give rise to some of these beliefs. So I'm going to describe some of these subtypes of legal cynicism and to try to share with you very briefly what some of these underlying factors might be. So the first subtype of legal cynicism that I mentioned has to do with this idea that legal immigration system itself is punitive, even though on the books it's supposed to be completely civil, administrative. So the detainees, as I mentioned, are well aware of this legal distinction between immigration being civil and versus criminal incarceration being penal, obviously. But in practice, a lot of them talked about just from their experience of sitting in detention facilities, that there really was no difference in substance as they experience their confinement. So we have Delmy, who says, inside detention, it makes you feel like you're the worst criminal, the most wanted of all. You tell yourself you're not, but that's how they make you feel. And then for detainees who actually serve time in criminal incarceration, they describe their detention, immigration detention, as being what's called a double jeopardy for them, meaning that from their standpoint, they were being punished twice for the same crime, the crime for which they've already served their criminal sentences. So we have Eric, who told me, well, I say that if you already completed your prison term, why do they have to take you back and lock you up, right? So it's this idea of having to redo their criminal sentence all over again. So in terms of some of the structural factors that might be underlying these kinds of beliefs, what the detainees often talked about is the conditions of confinement. So the idea that detainees are required to, all of them, have to wear government-issued prison uniforms, no different in appearance than what criminal defendants have to wear. They're restrained when they actually have to be shackled when they're transported from facility to facility to go to immigration court. They have to be shackled, and a lot of the detainees actually said that while they're having their bond hearings before an immigration judge, they had to be restrained during their hearings. Their daily lives are defined by really strict regimens and routines. They are under constant and strict surveillance, and contact with the outside world is very minimal and difficult. Now there's one structural factor, though, that the detainees kept mentioning over and over again as being the factor that in their minds really is what makes them think that detention is an extreme form of punishment, and that's the indefinite nature of it. So when we asked, among the detainees who had criminal incarceration experience, which experience was worse for you, immigration detention or criminal incarceration, 47% of them said immigration detention was worse, compared to 40% who said that prison or jail was worse. And what I find in the survey analysis is that it's this the 40% result isn't really a function of how much time they've served in detention versus criminal incarceration, or how recent their criminal conviction was, or any of that. Instead, what the detainees were telling us is that you just never know when you're going to get out. If you're sentenced through the criminal justice system, you at least have an end date. In immigration detention, you never know. You just don't have an end date that you can look to. as a finite endpoint, and that to them is imposes an extreme psychological trauma. So we have Miguel here, for example, who says, you never know how long you're going to be locked up. I already had a year and a half in detention, and I was hopeless. Now, in terms of some of the interactional factors that might underlie their belief that the legal system is punitive, I explore their interactions with detention facility guards, and what the detainees point out over and over again continually is just how stigmatizing this experience is. And in particular, there are certain kinds of treatment from the guards that seem to convey a deep sense of moral condemnation from the guards to the detainees. So we have one detainee who told us, we're there in detention as if we had a deadly infection, like we're going to contaminate you. We have another detainee, Juan, who says the guards know there's nothing you can do about it. Anything that you do in detention, you're going to get a count against you in immigration court. And so their interactions with the guards are constantly being played out over this cloud of what is going to go into their detention file, which then will get transferred onto their immigration file. The second idea, and I'll try to move this through this quickly, is this legal cynicism that has to do with the idea that legal rules are incomprehensible by design. And so, they're really well aware that they need legal representation, which they don't have a right to in terms of government-appointed counsel if they can't afford one. And then this notion that this happens because the system actually does not want them to have legal counsel or to have legal knowledge. So this idea that they just find it extremely difficult, if not impossible, to understand what the law is that is impacting their daily lives in detention is really well illustrated by one detainee who says, when I asked him, where is your case in the process, he told me, I don't know. First of all, actually, this is a pretty common response. I'll ask them, is it before BIA, before Ninth Circuit? Their response is, I don't know. First of all, I would have to be able to understand my own legal situation, which I don't, but it just seems like everything is so confusing. There are many steps, many things. Oh my God, it's like the court system doesn't want you to be free to do anything. This is the quote that I gave you at the top of my talk. This idea that they feel like the system is actually wanting them to just give up by placing all these hurdles in their way in terms of providing them legal knowledge. I also focused on what are the institutional barriers to gaining knowledge. So obviously there's lots of challenges for detainees in detention facilities to gain legal knowledge. In terms of having representation, if they lose their jobs because they've been detained for long periods, they cannot afford a lawyer. Even for people who can afford a lawyer and who have hired a lawyer, it's difficult to get attorneys to actually come out to these remote facilities to actually have interviews with them. And then there are, of course, challenges to accessing materials in detention. The quote-unquote the law libraries in detention facilities are made up of basically a couple computers with legal databases for them to access oftentimes outdated legal materials. In terms of interactional factors, there's a lot of talk about certain kinds of interactions with ICE officials that would suggest to them that these officials are intentionally withholding legally relevant information or actually intentionally misinforming them. So we have one detainee who said, I didn't want to leave the country. He was basically convicted of a drug offense, and this happened when he was 18 years old, and he says, I didn't want to leave the country. I've been here since I was 2 years old. I was terrified to go. I didn't know, I had no idea. I was 18 years old, and ICE officer told me, sign right here so you can go to Tijuana. You can be eating tacos tonight. She told me, you don't have a right to see a judge. You don't have a right to an appeal because you're just a fucking drug dealer. You're just a drug dealer. Nobody wants you in this country. I apologize. Okay. Okay, the last thing that I want to focus on, the last subtype of legal cynicism is this idea that legal outcomes are arbitrary, right? And so let me just give you a sense of what that looks like from the detainee's perspective. This idea of luck and lottery comes up a lot when they're talking about what might happen to their cases. There's also a detainee who explained this in some detail about what immigration judges and how they're making their decisions. So if the judges are having any problems in their homes or if they get upset, everything changes. I mean, we saw it all the time because one day some detainees would come back from court and they were all happy because everybody got bond. And then the next day, nobody got bond, and they're talking about how the judge was just throwing everyone out of court. So when we asked them, how much opportunity did you have to actually present your case in your bond hearings, majority of them, about almost 60%, said no opportunity or not much opportunity at all. So you can imagine that those kinds of interactions with judges might be in some ways shaping their ideas about what immigration judges are doing when they make their decisions. So let me just, I've sort of thrown out a lot for you to think about, but let me just end with a couple thoughts about what I think are some of the key implications of these kinds of findings, and then I would love to just open it up for discussion. So first, I think it's possible and likely that these kinds of legal cynicism that I've just, a little bit slice of which I've shared with you, may have really significant negative effects on the detainees' willingness to actually pursue their legal relief to which they're entitled to under our laws. A lot of these detainees actually have valid legal relief that is available to them. As I mentioned, they've been in the United States for a long period of time with deep social economic ties. The fact that they experience detention as punitive, as punishment, especially the indefinite nature of it, combined with their belief that the system is designed to intentionally keep them from accessing legal knowledge that's necessary to navigate the system, and that ultimately their outcomes are going to be random and arbitrary, that those kinds of beliefs, I think, might mean that for a lot of detainees, there really is very little incentive for them to pursue the legal relief that they have available to them. So one detainee, Jose, actually told me, you just want to sign and get deported after a while. You just want to get out of there, get out of detention, period. The second thing, and I'll just end with this idea, I think it's possible and likely that the diffusion of these kinds of cynicism and distrust of our legal system will be much wider in reach than we might assume currently. So for example, there are actually a growing number of studies in the criminal justice context that shows that context, with one part of our government or one set of legal authorities can really be a bridge to perceptions about other completely unrelated parts of our government and agencies and legal authorities. So you can imagine for non-citizens who have to navigate our legal immigration system and how their ideas about how our law functions and how our legal authorities act outside the immigration system might be shaped in fundamental ways by what they experience in our immigration system. And then we also have to worry about intergenerational diffusion of these attitudes, given that a lot of them have children, especially US citizen children who will be in the United States. And then that brings me to my third argument that I raised at the top of my talk, which is this idea that we ought to be taking a much broader, inclusive view of what communities are being impacted by our immigration enforcement policies, which is to say, even if you deport everyone, right, those people are going back to their communities in their origin countries, and we ought to be concerned about diffusion of these ideas and attitudes about our legal system, basically around the world and around the globe. So I'll just end there, and thank you.
Thank you so much. I know that both really speakers can continue to talk about their, research for a very long time. But I also wanted to include, your thoughts and questions. And before we even start the conversation, we heard what the detainees say. But what do we hear from the other side? I mean, from the administration, how are these immigrants who express their cynicism, how they experience detention, they're viewed as really, criminals who are routinely victimizing Americans, that they disregard the rule of law, and that they pose a threat to people in communities and across the U.S. So I mean, it's really very interesting to look at the two perspectives and how, they see themselves as opposed of how now the public discourse is about, who they are and, how they are defined as being a threat to the communities. So these are some of the issues that I hope, we could start talking about. And I wanted to open it for a few questions first, then I want to go back to the panelists and ask them about their ideas to reform the system that we've heard about. So please feel free to come to the microphones. You can come to either side if you have any questions. But if not, I can start with mine.
Good morning. I just had one question just on what Wafa, did I pronounce it correctly?
Yes, that's correct.
Mentioned about the view of threats posed by immigrants, whether legal or illegal. And as everyone is aware, during the campaign and since then, President Trump has emphasized the stories of American citizens whose loved ones were the victims of homicide at the hands of illegal immigrants. And those are very graphic, very strong, very powerful examples. And in response to that, mentioning one or two studies, as Michael Kuhn mentioned, is kind of thin gruel as a response. So in the public discourse, to counter those examples provided by President Trump, does anyone have any idea about some other types of messages that might be more effective than some academic studies?
Yeah, I was actually having a conversation about this at the reception last night, so it's fresh in my mind. Yeah, but as you mentioned, those handful of people that they pull out, and this is where the academics kind of come in, or in statistical terms, what we call outliers, right? There's if you want to find a murderer, you can find a murderer in any demographic group, whether it's immigrants, whether it's black, whether it's white, whether it's lawyers, whether it's college professors, whether it's guys named Donald, like whatever you want to find, there's a murderer in that subset of the population for sure, right? But they don't typically represent the population as a whole, and so we need to do a better job of describing what is the true state of the population. But again, nobody likes to listen to academics because we're wonky and we talk about math, and it gets annoying and tiring. But one thing that we could do as a community is start pulling out outliers from the other side of the distribution, right? Create the other side of the narrative and talk about all of the great immigrants, legal or otherwise, and what they're doing in our country. And that was really one of the motivating factors for the DREAM Act, right? Was we took a handful of really excellent, high school and college students and said, look at this, these great things and all this potential that they have, and then they're going to be deported to Mexico, and we're going to lose all this great talent, right? And so pushing that counter narrative of the other side, right, of the good things that immigrants are doing can really go a long way. From the academic side, and I'm guilty of this myself, is we do a really bad job of explaining what we know to the public, right? We're really bad at communicating most of the time. And so when it's also frustrating for me because not just that, the murderer example, but as an economist, every economic argument you can make against immigration, or every economic argument that is made against immigration, is patently false, right? They all sound intuitive, like they should be true, but when you actually run the numbers, they're not, right? And so it's partially on our side, because if you ask any economist, well, maybe not any, but 99% of economists out there, what are the impacts of immigrants on the economy? They're going to say they're great, they're good, they do wonderful things for our economy. You ask the general population, and they have the opposite effect. So there's a clear breakdown in the communication between academics and the public. And as academics, we definitely need to do a better job. But I have a hard time getting my students to listen to me, let alone the general public. Right.
And I wanted to add, that is why I believe that, everybody is needed from the community to be part of this discourse, because the organizers, the grassroots, have a very different approach, and they are much more vocal about telling the stories. And we have seen actually a shift starting with the Dreamers, when, before, immigrants were really afraid to stand up and say, I'm an unauthorized immigrant, but this is my life, this is my contribution. So I think that's why it is really important to have these discussions and to include all aspects, because lots of times, as an attorney, we use all these terms that nobody cares about, and even when we write a story about a powerful case, we tend to talk about what great things we've done in terms of legal relief, and it's important now to also address the emotional part of the equation. The same way they're publicizing all this, horrible acts by immigrants, there needs to be, partnership with the media, with the grassroots, with the community, in order to really highlight the true face of the immigrants. Those of us who work with them were really inspired by their, ability to start over, their resiliency, and the great things that they bring to us and teach us. So I think it is on all of us to really include more people to be part of the conversation. I believe that, just to say the truth, the researchers are very important, because they also throw these statistics at us all the time. So I think it has to be a multi-layered approach in terms of changing the public discourse and highlighting what immigrants bring to us here as a country. So,
I would like to ask a question a little bit of Emily. I really liked your comments from the people who were in the system. I didn't like them because I didn't like them. I found them challenging. My question has to do with the indefinite nature of the holds. We had a case that I'll just briefly give you quickly. It was a high priority removal, Rigoberto Salas, and he was adjudicated for a cancellation of removal and adjustment of status, and we won the case, but it's been appealed, and they continue to detain him in the detention center. No date has been given yet in 2.5 months since the case was heard. There's a new petition for bond hearing was denied, and the reason for the granting of the cancellation was for the extreme hardships on the family, and the family is deteriorating. I'm working with the family, and I'm trying to help them through this process, but the indefinite nature, is there any recourse to the indefinite holds that these people are going through?
So what you just described actually sounds very typical of the detainees that I've met in these detention facilities, and there's actually, so in addition to the Rodriguez litigation that I mentioned, that was the basis for this particular study, which basically allowed the detainees to have these individualized bond hearings after a 6-month period of continuous detention. Other district courts and circuits have been affirming these kinds of similar injunctions. Of course, it doesn't actually solve the problem in the sense that if the detainees are denied bond, they're still going to be back in the same situation of indefinitely waiting for their cases to come to an end. It's also difficult because appealing the bond decisions you can appeal, but they're rarely ever reversed because the immigration judge has a lot of discretion in terms of making that decision, and the BIA is not going to reverse that unless there's some extenuating circumstances or some changed circumstances. And so, unfortunately, I really don't think under the current system that we have, there is much legal recourse.
Yeah, absolutely.
First of all, thank you for that excellent presentation. It's really helpful. And I was really moved too by the accounts of the young people in prison, and I'll just call them prisons, of them thinking that this is designed to cause them to self-deport. And I'm sure you're familiar with the example of this a Mexican asylum seeker who was a journalist who was, after months of incarceration and was represented by counsel, did in fact permit himself to be deported to Mexico. He just gave up. And I'm wondering what you think if in the presence of all this evidence, whether detention really is intended for that purpose, to cause people not to pursue their legal remedies.
I mean, as a practicing attorney, I do believe it is. I mean, that's what we see day in, day out, and it is really designed. First of all, the location of the detention centers, they choose the most remote where there is no access to attorneys, number one, and where they cannot have the support of families or being able to be, and also, I mean, the way, having even a system that is called civil, while it is really affects their life and livelihood and could end by them being killed if they return to their country. So I mean, maybe I'm a cynic too, but I do believe that it is designed this way, but maybe from your perspective, you have a different answer.
I was just going to say that when they opened the first family detention facility, the Secretary Johnson, Department of Homeland Security, actually came out and made an announcement that one of the important reasons why we need to have this is to deter, to send a message to people in Central America that they're not welcome, that they're going to be detained in these facilities if they come, and that is as strong a message of deterrence as you can get, that they're going to have to suffer through this process if they come. And so I think there's actually evidence that shows that the government policy explicitly is to use detention and other kinds of enforcement practices as a tool of deterrence.
Hi, thank you all very much for your presentation. A couple of comments and then a question. Couple of comments. Everything you were sort of saying about the attitudes of immigrants in detention really echo what I think you would hear from African Americans in the criminal justice system. And so I think one of the things that, would behoove us to be thinking about as we're trying to expand the conversation is building allies across communities. Because sort of the mass incarceration that has been very much an issue in the African American community is now very much in the immigrant community, and the bed spaces that have been emptied out because of low crime rates have been filled up. And so sort of expanding that dialogue where traditionally sort of those communities in some spaces have kind of been pitted against each other in some ways. And then second, in terms of also broadening the conversation, something that Don mentioned about needing to involve municipalities and elected officials, because there is just terrific research, terrific stories. We don't lack for, wonderful, compelling stories. What we lack is a political process where change can be implemented. So I think that also needs to very much be, and it's very much the long game. And then just a question, when you were doing your interviews, did you control for folks who had attorneys and those who did not have attorneys? And did that make a difference in terms of attitudes? So I was just curious about that.
With the qualitative data, there's no way to do these kinds of statistical controls that you might think of when running regression models. So there wasn't a way to actually do that necessarily. But what I can say is that for a lot of people who do have attorneys, they've gone through a cycle of attorneys, a number of them before their current ones, for lots of different reasons. A lot of them having to do with the difficulty of communicating with their attorneys to figure out what the attorneys were actually doing. And then oftentimes, as I mentioned, it's difficult on the part of the attorneys to actually take on these detained cases for the reasons that we can imagine. And so the kinds of legal system that I shared with you were actually pretty prevalent across the entire population, whether or not they had representation. On the margins, there might be, so because this case drew a lot of attention, there were a lot of pro bono attorneys who were really dedicated and committed to serving the legal needs of these detainees. So the representation rate in my study is much higher than the general detained population, which is about little less than 50% were of my study sample had representation. In general, the representation rate is extremely low among the detained population. So I would imagine that it doesn't necessarily make a significant difference for the run-of-the-mill type of detainees with the kind of problems they have. First, retaining counsel and being able to sort of work through their cases with their attorneys from in detention facilities.
Okay, thank you.
And I wanted to go back to your comment. Thank you for it. This is one of the things that I think we're seeing a change in, kind of widening really the number of people that we're partnering with in terms of advocacy for immigration. And this came up the same after September 11. I can tell you for the Arab and Muslim community, I mean, they felt that they were targeted and all of that, and that's when they started to realize how much in common they have with the African American, kind of group who have been experiencing the same treatment. So I feel like, and hopefully this could be one of the things that we could discuss during this conference is how to include non-traditional, partners in the fight. And the truth is, African Americans have had experience in this. They have lived through it. But what has happened because of the socioeconomic reasons, there has been this really competition between the two communities, the Hispanic and the African American instead. But I honestly am seeing a lot of movement towards working together and starting to really acquire kind of a voice and much more stronger political power in order to effect change, because unless we all kind of work together, it's not going to happen. So I don't know if Michael, you. Yes, go ahead.
Let me cut you off, sorry.
No, I'm fine, yeah.
I had a question for Emily specifically about immigration judges. So about 10 years ago when I was in law school, I interned at immigration court in Tucson with two immigration judges who had been at the Eloy Detention Center for a long time and then had just been moved to Tucson and were doing a lot of video hearings. Those two people in particular, because they had been at Eloy, probably had some awareness of what the conditions were like. But I guess I'm wondering, kind of to the point of some of the comments that the detainees gave about whether the immigration judges were having a bad day or any of that kind of thing. I guess I'm wondering how well, on average, immigration judges really do understand the conditions of detention and what's going on. And then sort of related to that, the detainees themselves, I was really struck by the fact that they all came in orange jumpsuits. I mean, we're looking at the screen, but obviously that's a trigger in a lot of people's minds, right? That's what prisoners often wear, so it kind of puts you already in that frame of reference. And I just, even sitting here, was thinking about if they wore like green scrubs instead and they looked more like doctors and nurses instead of prisoners, if that would just be enough to kind of change a little bit there. But because so many of them were just saying, whatever, tell me what I have to say, I want to get out of here. I just want to go home, I want to take the bus, drop me off at the border, whatever you have to do, I'm done with this facility. And I guess that's like a multiply compound question, but I'm kind of wondering if the immigration judge is really if you have access to them really even to kind of have those conversations.
Yeah, so I don't actually have direct access to immigration judges, and if anybody here has connections to EOIR that would allow me to study immigration judges by interviewing them, by running experiments, I would love to hear from you. But what I have been able to do is to actually do statistical analysis on variations in terms of their bond grant deny rates and at what amount they set the bond if they are granted. And what we see is actually consistent with what other studies have shown in terms of IJ decisions, which is that there's an enormous level of variation across individual judges, and that those variations cannot be explained by anything, really. And so, I don't want to make any generalizations about immigration judges that are oversweeping, but I do think that immigration judges on their ends face enormous amounts of pressure, right, to move their docket, and to, for most of them to in good faith, do the best that they can under the circumstances and the challenges that they face, and the impediments that they face to efficient judicial decision making. And so, but the idea that you raised that, just them having to see the detainees, in their prison uniforms, what effect does that have in terms of their implicit bias, in terms of their heuristics? Those are the kinds of questions that I would love to be able to address directly by talking to immigration judges and be running experiments. And so it sort of brings us back to this frustration I have that data collection in this area is just so difficult.
And I think the other issue is jurisdiction that is really affecting, because judges kind of see themselves as having nothing to do with detention in a way, which is in a way not completely true, but partly true. So this also, I feel like, has an effect on how they respond to that. The fact that this is kind of a decision by ICE more than the judges, other than the bond.
Until they get to the bond hearing, right?
Other than the bond, I agree.
If they have some real understanding
Absolutely.
of what it's like, then perhaps they have they're able to use their discretion in a better way.
Very true. And I think we only have a few minutes, and I wanted to go back to the panelists to ask them if they have any ideas about how to reform this enforcement system that we kind of talked about. So, Michael, I will go to you first.
Yeah, I mean, it's going to be tough, for sure. I guess since the room's full of mostly lawyers and law students, keep suing, for sure. Part of the reason that Secure Communities was changed is because it got a lot of heat in court under a number of different issues, right? So they challenged the legality of whether or not police forces actually had to submit this data to Homeland Security. They challenged the legality of whether detainers were constitutional if you're holding somebody for 48 hours without charging them with anything, whether that's legal or not. So there's, especially now if we're starting to see evidence of racial profiling, racial bias, again, that's a civil rights violation that you can sue against to rework these programs. The other thing I mentioned earlier is spread the word, right? I mean, a lot of what's driving immigration policy is myths and we'll call incorrect facts. If you get the truth out there, if we get a better understanding of what the immigrant community is actually like and what they're going through, that might change popular sentiment. Again, this is something that's going to take many, many years. But probably the most important thing you can do is get politically active, right? The 287G program is part of immigration law. So to change that, you're going to have to change the law. Secure Communities is part of executive policy. To get that, we're going to have to change the executive. I mentioned earlier that a lot of times for the 287G program, a lot of times sheriffs can unilaterally implement these programs, but also a lot of times sheriffs are elected positions, right? So if you have a sheriff who implements this program and you don't want it in your community, vote the sheriff out of office. That's one way to get policy change, and it's particularly important for our perspective to act, especially as Dr. Kerwin said. We need to speak up, primarily because a lot of immigrants can't speak up for themselves in the political realm. That's why they make such good political targets, because they can't vote against the politicians. And so we, as citizens with voting rights, actually have to be the ones who move the policy, and we have to inform their decisions. These are all definitely not quick fixes, for sure, but I think that's probably the best route we can actually take is changing it as a community.
Emily?
So there's a lot we can do. I'm going to focus on detention, just because it's overwhelming to think about enforcement and immigration policy more generally. There's so much that we need to do on many different fronts. But in terms of detention, I think obviously there's a lot we can do to improve the conditions of detention through lawsuits and other ways to improve, provision of medical care, to eliminate deaths in detention, eliminate isolation units that are being used for purposes of discipline in detention, etc. We also need to work on eliminating mandatory detention. So the Attorney General should have the discretion. Well, it wouldn't help too much to have the current Attorney General
Yeah,
to
have the discretion.
But to eliminate mandatory detention that makes it impossible for detainees to be held without any kind of individualized bond hearings, that ought to be changed. We should also be working to think of creative ways to allow ICE to release people on alternatives to detention, right? So there's lots of efforts going on right now in different communities and community organizations to actually work and cooperate with ICE to come up with ways that they can help increase the court appearance rates of people who've been released. There are studies that have shown that they're very effective and very cost-efficient methods to ensuring that, and also providing sort of wraparound social services that would ensure the well-being and safety of these people who've been released, so that they have stable housing where they can actually have an address where they can get notices and reminders about their court appearances. All of those things ought to be something that we need to be thinking about. How can we test the effectiveness of these alternatives to detention programs, rather than using detention as a default strategy, right? So confinement should be the exception rather than the rule. And then lastly, I think we need to think about reforms in immigration courts, right? Obviously, we need to hire more immigration judges, which we are doing, but clearly, we need to create more consistency and transparency in our immigration courts. And one thing that's been debated for a long time without any movement is how can we move immigration courts out of the executive branch and into judiciary, so that there can be judicial independence. So those are some of the things that we have to talk
Thank you so much for sharing your research, for giving us ideas about reform, and we just touched the tip of the iceberg, and hopefully there's a lot to be discussed during these 2 days. Thank you all.